Hello, everyone. Steve Ankerstar here. Thank you so much for listening in if you're following online. And thanks for the folks that came out and braved the rainstorm we had 15 minutes ago to come out here to the presentation in person. Today, we're going to do the part two of the estate planning series. Part one, pretty basic, also easy to understand. Part two, not as basic, a lot more variables. So, this is what I would call an awareness of what's out there. And if you hear something that says, like, I think that's me or that applies to my situation, then it's time for a separate talk. And first of all, with your financial planner, if you have one, or with your advisor here at Ankerstar Wealth. And we'll sit down, we'll kind of talk to you about the basics of it. And then the big disclaimer, of course, is I am not a lawyer. Neither is anybody here on our team a lawyer. We do have Mickey that we partner folks out to. But yeah, a lot of these topics, I'm going to get you enough to be dangerous, right? To know about it. And then when you Google search it, then you can know a little bit about what's going on. But when you sit down and actually put pen to paper and put a trust in place, you'll have a lawyer that goes and sits with you who does that entire process. Okay. What is estate planning? We want to take care of ourselves. We want to take care of the people in our lives. So when we have what's called the empty chair scenario, where somebody's not here, making sure that everybody else who still is here is fully taken care of at all times. You can't think of everything, but this is a kind of a here are the major things to make sure that everybody's taken care of. So that's the first piece of it. Secondly, there's a taxation piece. There's smart ways to do things to be able to protect yourself from the estate tax. Right now, that estate tax is up at high 20, 28 million or so. So you're like, well, maybe that's not me. But also, that's a moving target, depending on who we elect, can certainly bring that back down to where it is you. And that can happen all of a sudden. So you want to know that these things are out there just to know what your options are. And then the last part of it is if you've heard of probate. Probate is a public process. So the stuff goes on file and people can see what you have. A lot of folks want to keep, especially as your wealth goes higher and higher, really doesn't want everybody else to know what you have. So when it goes to your heirs, they aren't sitting there going, okay, these people are now targets because we know how much money they have. So those are some things to consider. This slide is the ones we talked about last week. We just talked about the purpose. Some of the documents you may have in your lives already are wills and trusts. The trust we talked about before, revocable trust. All that means is you can change your mind, right? This is what I think today. I paid some money to a lawyer, put it all in place, and put what I thought to believe the best path forward for my assets. But things change. Birth of children, death of anybody in the wheel, a divorce, any of those major life changes can lead to a situation where you would need to go into your revocable trust and change it. And then power of attorney, many of us have dealt with that from a limited power of attorney for somebody buying a house for us, or like we invest with our folks, it's a limited power of attorney, it gives us that authority, to a full general power of attorney, which is something you consider if you maybe go overseas for a while, like I used to deploy. So I would give somebody a general power of attorney, or later in life, if you want somebody to take care of you, you can hand over general power of attorney. And of course, the authority that goes with that is significant. So definitely want to talk to somebody about that. And then lastly, the beneficiary designations. Those are the accounts that you have with us. We those basically pass to whoever you have on that specific account. For IRAs, it's going to be your spouse, required by law. The other taxable accounts, you have some options. So if you want that to go to the grandkids or a sister or something like that, then you can specify that. Okay, some ethical considerations for all of these things is when you build a trust that's revocable, which is what we talked about last week, you can change your mind, you don't lose control. You can make it better, change it, take it back completely, do away with it. However, when we start talking irrevocable trust, which is where now you go into the advanced piece, that means you set it and it is. You have lost control. You've officially taken your account or your house or your whatever it is you decide to put into the trust. It is at this point now and forever gone for the rest of your life. So there's many advantages to that, but changing your mind is not one of them. So when you go to set this, when you go to set this up, you are losing control of the actual asset. So you want to make sure you've thought this for some time and very clearly. Also, communication with beneficiaries is key. That's always a personal opinion, but if you're sitting on a lot of money and the kids don't necessarily know that, which there's a time and place, and we're all parent, or whoever's parents can decide on their own what you tell your children about your wealth. But certainly, if you're setting something up that is significant, where your assets are leaving the family and going somewhere else, that's something that probably should be expected. So upon your passing, that's you're not, that's what they make all the movies about, right? Either the trust or the trust doc or the will gets popped open, and then all of a sudden somebody's highly offended because they get $0 for an entire lifetime of pain they've caused their family, and thought that that would all be forgiven and forgotten. Not true. So just think about what you want to communicate with your beneficiaries about this. Prevent disputes. So when you think trust, and especially an irrevocable trust, that's a legally binding trust. So you are given that away with a whole set of rules that goes with it, and a trustee will execute that on your behalf. However, it can still be challenged in court. So think of sort of like, well, why would I do it then? Well, if you're doing illegal stuff, then it can be challenged in court. So Bernie Madoff, right, knew for decades that he was going to get caught. Right, he started a Ponzi scheme. Everybody knows the end of the movie, and so how long can you keep dancing until you're officially caught? Well, since he had done that, he was also taking a lot of his assets that he was making, acquiring wealth, and now trying to shelter that through a trust, thinking I'm good. Well, no, it just takes a court order to go, no, all that was illegally obtained and you can crack into it. But for the most part, when you set up a trust, you're preventing disputes. So think of your kids wanting to argue over your assets, that sort of thing. Pretty well, if it's in a trust and you've followed the law your whole life, then it's going to help prevent or reduce disputes. Okay, the grantor intent with beneficiary needs, you can put, what does that mean? You can say something in your trust because you felt that way at the time and then you made it happen. And then some things change with the beneficiaries. Somebody gets sick, somebody can't work, somebody all of a sudden who was not so great at being financially responsible adult, all of a sudden now finds financial responsibility, finds Dave Ramsey, that sort of thing. And now they're the perfect adult, that you've already, through an irrevocable trust, given that away. You can't take it back. So consider that. And then trustee. So when you think the trust, you're the grantor, you're the one authoring the trust. The trustee is the one that executes the trust. That can be you in a revocable trust, because you can change your own mind, rewrite the trust, and kind of do what you want. In an irrevocable trust, it's not you, it's somebody else. If you don't know of somebody who should be your trustee, then there are firms out there that can perform trustee duties. Some lawyers do it. You'd have to talk to them. But you certainly want to pick somebody that you know and trust, or a reputable firm that knows how to do these things. Okay, so beyond the revocable living trust, here we go. All right, so when think of this slide's largely talking about control, and irrevocable terms are locked at the creation of the trust. So there's no cracking it open and making changes to it. You do give up control. The positive of it, so if you put, say, a house into an irrevocable trust, you don't pay taxes on all the gains. So you can put things into trusts that would highly appreciate or highly anticipated to be appreciate. I'm holding up a Bitcoin there. The If you think it's, stock or any things like that are going to really go up and you don't want to pay taxes on all those, then you can. An option is to put it into an irrevocable trust, and set beneficiaries that way. And then protection from creditors. This is where, yes, things you put into an irrevocable trust are no longer yours. So if you get sued, if whatever happens, creditors cannot come after that asset because it is literally not yours anymore. Okay, here's the eye chart. So don't bother really reading that, other than maybe the headlines if you can see those. Um, so the first one is just the basic irrevocable trust. That kind of is the, I have something in mind and I want to do it very specifically. That's kind of the basic level. A special needs trust, many of us have heard of those. If you have a special needs individual anywhere in your family, it can be yourself if you end up getting disabled to where you now can't either work or fully function as an adult, or it can be a child where that's set up while they're a child and they enter adulthood, understanding that somebody's probably providing most to all of their care, and that there's a trust in place for funds to do that. The next one over, a charitable trust. Charity is a great way to give away money and not pay taxes on it. So there's a couple of different options that we'll go through on a further slide. Next one down on the left, generation skipping trust. So normally we all think, okay, our wealth is going to our kids. Maybe the situation is where our kids have more money than we do, and then they don't really need it. So can I legally skip it to the grandchildren or great grandchildren or whatever your family line is? Yes, you can do that, and yes, you can do that through a trust. And there's some things to think about there, but you can do it. The grantor retained annuity trust. So think of that as, say you have $1 million in an account. You're like, I'm never going to touch the $1 million, but I don't want to put it in a trust and kind of give it away yet because I want to live off if you think $1 million at 5% kicks off $50,000. So I want the cash flow. So I want the milk, but I don't necessarily need the cow. And I know the cow's going to my beneficiaries. You can do that while everybody's still alive through this a grantor retained annuity trust. So the asset goes into a trust, which will eventually go to your beneficiaries. All you get at the time is the income that's coming off of it. You can do that in reverse too. You can give the income away while you keep the asset, but that's less common. A marital trust, I will just say that this is out there. It is when think blended families. So we'll talk more when we get to the actual slide. There are a unlimited number of scenarios when it comes to blended families of things that can happen. So that's an option for you. The QPRT, Qualified Personal Residence Trust, if you've ever heard, hey, I should put my house in a trust and give it to my heirs, and then I will just live there until I don't need to live there anymore. And that's going to save me on taxes and save me money, and I'm guaranteed to live in my house forever. You can do that through a QPRT, and we will talk about that. And then the last one is a testamentary trust. So when you think testamentary, that means that it's written in the will, not in a trust document. So you can go to your lawyer who's putting a will for you, and you can simply say something upon my passing. I would like a trust to be established, and here's all the words I'm going to put, and that is legally binding. So when you pass, and that's discovered when the will is popped out, then that is basically the trust that becomes a thing upon your passing. And generally, nobody knows about those until the will's over. Okay, we talked about tax benefits, asset protection, Medicaid planning. I almost deleted this, but there is a way. If you are the person who says, I want to pass everything I have to my almost my last dollar, and so I basically pass away broke, that you can use an irrevocable trust to give everything away. And then, yes, you will be on Medicaid and have roommates at the nursing home because you're back on the government till, if you will. We don't advise that here at Ankerstar Wealth, but you can do that if that's your goal. Okay, special needs. Just look at the two types. So most of you are familiar with the third person type, where again you have a child that has special needs, is raised by their parents till the age of adulthood, which is different in different states, and then you establish a trust with a certain portion of their assets. And they may be able to work either not at all or some or fully, but either way, there's a pot of money there to take care of them. Realizing that if it's your child, they're not going to age on the same schedule you do. So eventually, you're not going to be around if everybody passes according to age, and then the special needs child is now an adult and needs all that money for somebody else to take care of them. These are pretty straightforward. Generally, it's a big pocket of money, and then the trustee on this can be you as a parent. But when you're not around or something happens to you, then another trustee is going to come in and care for that person. Charitable trusts. These are the two types we talked about, where on the left-hand side, you receive the income stream off of the asset. So say it's $1 million, you give it to charity, but you go, I want to get the money off of this, want to get the income stream, but eventually when I pass, that money's going off to charity. Or the other way is you can do a charitable lead trust where you take $1 million, or it could be 100,000 or whatever the minimum is, and you take that money and now you put it in a trust, going, I know I want this to go to my beneficiaries, but while I'm still alive, I don't need the money. I want the income stream to go to a charity. So say you have $1 million, you say I want to support breast cancer. While you're alive, all the income from that goes to breast cancer. And then when you pass, that money comes back to the family. But it does lock it away that whole time until you pass away. So long-term long-term complications there if a situation changes. The tax implications I won't go into because it really is complex on how each of these is handled. But if you, especially if you file your own taxes, you do get a deduction for donating to charity. And it often can be a quite sizable deduction, especially if you bring it all into 1 year with the deductions that we have out there. So that would be something to sit down and look about what the tax advantages would be. Okay. The generation skipping transfer trust, things to think about is just because you want to do it because you have a lot of assets now. Say your kids have a lot of assets and you want to go straight to the grandkids. That is a great idea on paper. In theory, that works all day uh, until things could happen along the way. Say you have two kids, either one of them could run into some financial troubles. So just think entrepreneurs, right, where they're kind of farther out on the risk spectrum, if you will. Things are great and they make a ton of money. Well, they also have that like risk gene that is like, well, if I can make millions once, I can bet it all and do it again. That can be a reversal of a financial situation. Um, or once you spread it out amongst all of the grandkids, say you have 6 to 15 grandkids and you start pushing money and spreading it out, you also lose that ability to where if somebody runs into trouble there to be able to focus on any one of those individuals. And then last one, yourself. Hopefully, that if you're at the point where you're giving money away, I tend to think at least 5 million net worth before you really have the conversation. Um, but you could argue when that is. But when you think of giving money away, think of right up to the gift tax for each year is the amount you can do. So 19,000 a year per person. If you're married, you can each give that. So think 38,000 to each of your grandchildren. So that can add up. 15 grandkids, 38K each. So you're talking. If you put it in a trust, then it can grow and you can set an age for they get it. So maybe you think 20, well, the common age that is thrown out there is 25 as a mature adult. You could argue that and everybody's different, right? But that's a commonly accepted numbers. You can also structure it out to where if they graduate high school, they get 50,000. If they graduate college, they get 100 at that time. And then some people use ages. 25, 35, and 45 are the most common. By the time they're 45, they just get whatever's left, right? The remainder. So there's different ways you can schedule it out. Whatever numbers make sense to you is what you would use there. So why not use a UTMA? Well, depending on the state that you live in Texas, the age of adulthood is 21 as far as financial assets. The day they turn 21, that money becomes theirs, all of it. So if you're doing this sort of thing, you probably have a sizable amount of money. If you do 38,000 a year for since their birth, 18,000. I mean, you're talking where now all of a sudden instead of the young adult who's stepping into the world to be a productive member of society, they just got their meal ticket to now check back out, right, and not have to become a productive member of society because $1 million will last forever. Well, it should, but depending on the adult or depending on the type of person they are. Okay, the grantor retained annuity trust. Again, that's where you can hold on to it and um, you either give it away and you get the annuity payments. So give away the cow, get the milk, or keep the cow and give the milk away until you pass, and then you either way it goes on to your beneficiaries. But the important part to know here is it sounds like a great idea, but it's not your asset anymore. So again, if you have 10 million and want to give away a million and something like this, fine. If you have 2 million and want to give away a million and something like this, you're probably taking on more risk than you need to take on. Marital trust. So if anything, if you can see this, I should have made it a little bit bigger down there at the bottom, but I will read it. To there's these four are the most common, and then there's like 100 behind them. Provides the surviving spouse with varying levels of control depending on the specific needs of the family. So if you think of just use my family as an example. Everybody here knows my family for the most part. Um, so say I pass away and so without a trust, you were just using normal wills, right? Most families are set up to where One of the spouses pass away, the other spouse gets everything. With the kids as a contingent for the car accident scenario, you go on date night and it goes poorly, and then everything goes to the kids normally in an equal split. Kind of that's the straight family tree math. If you do that, then say I pass away, Irene gets our estate, if you will, and then subsequently she remarries, which actually I'm the type of person who says I want you to remarry, sort of thing. Live a happy, successful life with somebody else if I'm not around, not if I'm around, but if I'm not around. And then subsequently Irene passes away. Problem, right? Because now, if they know normal beneficiaries, the new husband is now getting everything from Irene, and now all of a sudden, his kids, if he had previous kids, that sort of thing, get our entire net worth and split equally amongst themselves, and everybody's like, "Woohoo, good for them." Our two children are left out in the cold. Now, if these things happen, certainly, there are situations where responsible adults all come into the room and say, "Hey, this was never the intent. Let's talk this out." Responsible adults get a lot less responsible as you add zeros to things. So, yeah, good luck. So, yeah, in this case, you'd want to set up a marital trust, right? Not from the initial early passing of myself, but as Irene enters into another marriage, certainly something should be stated. A lot of folks will do the, um, you know, 25% to the spouse, the new spouse that is now brought in, and the rest goes to the family. Some people do a third, a third, a third, depending on the numbers you're looking at. It's really whatever you decide. But so you're out there, so you're not unintentionally disinheriting your own side of the family. So something to consider. There's lots to read about there. You would really have to get into it to see what would be right for your situation. But that's the main goal is not to accidentally disinherit someone. Now, if you're trying to disinherit them, you can make it happen too. But if you're trying not to, and then there's the two kids on your side, three kids on the other side. Do we do a 40-60, 20 per entity sort of thing, or do we do a 50-50, or the net worths coming into the scenario are very different? Who knows? But there's a way to do that through the trust process. Okay, the qualified personal residence trust, that's where you're starting to age and you're in your house and you want to stay in your house, but you don't want the house to be yours anymore. So basically, you can give it away most of the time to your children and put it in a trust to where now it's your children's house, but it has a specific time that you are allowed to live in that house. So they can't get mad at you and boot you out of your house. So you get to stay in that house, and that's determined by the trust what that specific period of time is. And you should, or your lawyer would say you should, just go ahead and in case when you thought maybe you planned everything out to live to 95, that if you live past that point, then you can simply pay rent back to the trust. So it's kind of you don't lose the house ever really if you put that clause in. So estate tax benefits. So we talked about estate tax earlier. It's 13.9 million per person. So if you're married, that's 27.8 million. You're like, okay, well, I don't have to worry about that. Well, be surprised, right? If you have a couple million in your 40s and 50s and you're invested aggressively or starting a business, those things can add up. Certainly, the Austin real estate area, if you are in the real estate venture, things have 2x and 3x. So the largely the largest asset people have are their real estate, and this allows you to take the largest asset and basically get it out of your estate. So it doesn't count towards your 27.8 million. And you're like, well, it's not a problem. Just know that it's out there if it becomes a problem. If you end up with a lot of money, that's the way to do it. Okay, we talked about the testamentary trust. This is where you pop open the will and it says, upon my passing, I want everything to go into a trust and split up amongst my three children, 100,000 each right away. And then at 25 years old, I want to get them 25 of the remainder, 35 the other 25, and then the remainder at 45. If you write all that down, even handwritten counts, if you have that in your will, then that becomes a thing. What changes with this, and why your lawyers will say never, ever, ever, ever do this. Not speaking for all lawyers, but most lawyers will say don't do this, is because this does go through probate, so it becomes public, so everybody can kind of see it and challenge it, and kind of all up into your business if somebody wants to be in your business. So that's why you wouldn't necessarily want to do that, because then it would be obvious that your heirs have a lot of money, sort of thing. So which could make them targets. Who knows? Okay, the last thing we'll cover is, right now we've been talking about really you as a person. How can I protect my spouse, my family, my kids, my assets, and do the smart thing? This is now, what can you do through the business structure? So the most common question I get is, somebody has an exit event from a business. It could apply if you won the lottery. It could apply if you won the World Series of Poker, even, to where all of a sudden you have, 10 million that you didn't have the day prior, sort of thing. And the question people ask me is, can I simply stand up a business solely for managing my wealth? No. You have to have, and if you look right at the bottom, it says you can't, it has to be a legitimate business. Now, take those words and define them, but the IRS will help you out. But business, you can't just sit on your pile. You can't do the Scrooge McDuck, as I have heard. Sit on the pile of your wealth and count your Bitcoin. Um, but there has to be a business there. And it can't just be a shell company because it was a business. Now you buy it and it's like, oh, see, it's a business. So that's what you can't do. But you should all, if you have businesses of, and I would say, again, not an accountant, not a lawyer, but if you have a hobby that you're monetizing, yes, the words, yes, you should claim every income and track everything like you're in MBA. Okay. Well, at some point, if you start generating enough income, yes, you do want to say, all right, I need a business structure and I need to start paying taxes on this and those sorts of things. When that comes about, then you want to consider at least an LLC, or doing business as structure. That's going to provide you some benefits. Um, if it, or if there's more than just one person involved, then that's where the limited partnerships come in. And then if you were trying to do something with a family business, then you do a family limited partnership. The big picture is, if you are producing, you're selling T-shirts, and for rock bands that come to Austin, and you sell 10 of them, and you're like, oh my gosh, there's a business here. So, and then you sell like 1,000 of them. Well, some idiot, you want to protect yourself, your home, and your kids and your family from somebody who takes your T-shirt and hangs himself or something. That's a terrible example, but they do something to where there's a lawsuit resulting out of your business venture. You want to limit that to your business. You don't want that to come over into your personal wealth. So in our situation, we do have a swimming pool. We have people over. Somebody gets injured, they can sue us if there's negligence involved. Whatever, but that's limited to our personal wealth. It doesn't touch any of the businesses, and vice versa. Somebody slips on the sidewalk, please don't. Same sort of thing. Sue the business, at the family. And in our case, this is a two LLC, or a layered LLC protection, if you've heard those terms, where Ankerstar Wealth is a business providing the wealth management services, and the building, the Ankerstar Family Office Building, is its own separate entity. So if you slip on the sidewalk, you only get the building. So, or if something happens with your advising wealth management services, you only get whatever's holding there and not the building. So those are some different things to think about. There are business formation lawyers out there at all levels, so it's not like you're going to pay thousands to get some basic level advice. But start with Google, start with AI. AI, you can kind of get back and forth in a conversation with it. So that's where I would start if you're looking at this stuff. And then eventually, when you show up or call the lawyer and say, here's what I'd like to talk about, you're kind of armed with the information you need to have a quick conversation, which is better when you're getting billed at every 6 minutes, right? Okay. There's lots of reasons why you do it. That's why everything's on here, up to including probate avoidance. So consider at the end, there are trust options for businesses to, again, so not everything is out in the open should you pass away. Okay. The considerations mostly here is that why we put this slide in is these laws change. So literally, you could go home tonight and you're so fired up, you read up on this stuff for 3 hours. Good luck making it 3 hours without falling asleep. But you go down that road, you learn everything about it, and then we have the big beautiful bill that you may have heard of, and it's going to have some tax code changes. Well, not only will that one, but the one 2 years from now, 4 years, 6, 8, 10, 12, right? Tax code changes. So what you think is going to happen as far as minimizing taxes and maximizing deductions, that sort of thing, may change on you. Probably the worst one to, or the one that's most concerned is we move the Tax Cuts and Job Act 2017 moved that estate tax up to that 13.9 million per person. So it kind of moved it out of the middle class to the really the higher net wealth level. Realized the stroke of the pen, signed into law, and it should be back at 5 million, which is now applicable to a lot of folks that have had a normal successful middle class life. It's like, oh yeah, you could get there, and that would change things. So something to consider. Okay, these are just topics that the annual gift tax exemption is probably the most important one. So when you want to give money away to kids, which is a great idea, if it's for school, you can pay for everything, right? It's for education, just boom, just give it away. You can go out of pocket. If you're buying them a home, which we do talk about, is much harder now when a lot of us, we've got a couple generations in the room. But with my generation, if you graduated college, you got a decent job and you worked hard and saved 10%, you could have a home. You would kind of get at that home down payment around age 30. That goalpost is moved. you you cannot do it now if you're in a 20 something scenario. So parents might have to come back and help kids with that initial down payment. So that's something to consider. But that's generally, there's like up to 100,000, or there's some limit out there that you can certainly help with that. But assuming it's not for school and not for housing, their first house, that is, then you're tied to that 19,000 a person. But 38,000 if you're a married, if you're a couple, and that accounts for grandparents too. So I've always highly encouraged my parents to help out the girls, whether they need it or not, right? To bring money forward, sort of thing. So you can do that up to 19,000 a year per child per person. You can do that without filling out any tax forms. If you exceed that, you can. It just has to be documented, and that would be a topic for another day. Medicare, IRMA is a favorite term that's out there that it usually leads to a lot of frowns and makes people really mad. If you don't know what IRMA is, consider yourself lucky. You will someday. But when you're on Medicare, you're going to pay, if you're wealthy and have a lot of income, you're going to pay a lot higher premium, and it's a surcharge. There are ways to use a trust to reduce your income enough by giving away income producing assets. To where you don't qualify for IRMA anymore and don't get hit by that surcharge. Okay, this is just a couple to wrap up. In Texas, there's fairly favorable homestead exemptions on things, so just don't forget those are out there. If something happens and you get sued by a creditor or something, you will not lose your entire house, right? There's a lot of protection there. Other states are different, so that's something you would look at. And also your retirement accounts, same sort of thing. Somebody comes after you, sues you for whatever wrong they feel that they had. Then they come after you, but retirement accounts are for the most part protected. So they can take like your current assets, so they can't come after the stuff you've spent a lifetime putting together. Okay, last one, healthcare. There are some, you can get a very detailed healthcare directive if you have specifics. We talked about the other basic healthcare directives, including like a do not resuscitate order, which means if I die naturally while I'm at the hospital, they will try to save you unless there is a DNR in place. So that's a discussion to have before there's a loud beep in the room, because they're required by their oath to bring you back, even if you were like, man, that would have been a nice fade out right there. So, but you can get very specific as much as you want. Long-term care insurance is the another thing to where it's very expensive. If you're self-insured, what I call, a couple $1 million, I would not even worry about this at all. However, if you're less than a million, like, oh man, I would be hurting if I was hospitalized for 2 to 3 years, and that would take all my wealth. And that's when you would consider a long-term care insurance scenario. Okay, we saw this slide before. Just the ethical considerations. Certainly, in an advanced case where you are doing a one-way action, whatever you think at your 20s, 30s, 40s, 50s may not be what you think a couple decades later. If you look in the mirror and reflect on your former self, maybe don't know as much as you thought you did at the time. But yeah, these are one-way scenarios. So if you do want to talk to somebody about this, it's required some thought on your part. little bit of self-education, Google/AI, write it all down, try to kind of figure out what it is you're trying to do, and then engage with an advisor first so we can give you our best hack at it, and then eventually over to the CPA and the lawyer for kind of final adjudication on making sure that you're doing all the right things. Okay, there's your team here if you're interested and you're local. All right, questions for anybody, starting with folks in the room. And I don't have anybody monitoring online, so if you're asking questions in the chat, I don't know about it. We'll get back to you on those. Oh, oh. Well, so the question, since I'm broadcasting through here, the question is, when you start giving stuff to your kids, kind of what's the level of formality there that you can give, and is there a tax deduction? No. Well, the nothing that you're going to file on your tax form this year, but you're moving assets from your estate into their hands over the course of your lifetime. That's one side of it. The other side of it is, I know I'm providing more than $19,000 of care for my lovely children. Who's keeping track? I probably exceeded that, right? Not for the IRS, but I'm saying hypothetically. Yes, for the little stuff doesn't count. It's really when you start to move money between like bank accounts or brokerages that's very easily trackable. Or if you start trying to, gift them Bitcoin, that sort of thing, then you would want to make sure you stay under the limit there. So, all right. Any other questions? Good stuff. Nobody fell asleep, or at least that I just saw. So, a little bit of a dry topic. But thanks again for coming out, and thanks again for checking us out online. You have a good one. I don't. That's a good question. Hmm. Did I stop it? I stopped it last time. I just don't recall how I did it.